Good evening. My name is Elizabeth Kirk, and I, along with Mark DiGirolami, direct the Center for Law and the Human Person. So welcome to our annual spring symposium. This is now the fourth time that we're gathering together, and I think it's fair to say that our center is now an integral part of a genuine community here at Catholic University that's connected by shared concerns and shared commitments, and I think genuine friendship. So it's a great privilege to be here with you. Thank you for joining us. I'd like to begin by inviting you to pray with me, but since you don't have the text, I'll just say it. The opening verses of Psalm 1. Blessed is the man who does not walk in the counsel of the wicked, nor stand in the way of sinners, nor sit in company with scoffers. Rather, the law of the Lord is his joy, and on his law he meditates day and night. So our symposium theme this year is the ancient yet pressing question of the right relationship between law and virtue. Our title is from St. Paul's first letter to Timothy. Now we know that the law is good. And the verse continues, if one uses it properly. Indeed, how does the psalmist's blessed man use the law? He delights in it, for the law leads him not in the way of sinners, but to right action. The blessed man meditates on the law, not on the counsel of the wicked, for the law is the path to beatitude. The law for the psalmist is something that the well-formed person enjoys, indeed, that which he loves. That is the ancient intuition at the heart of our gathering, that law and virtue are bound together, and that the question of what the law is cannot be disentangled from the question of what kind of person the law both forms and requires. For this year's conference artwork, and here you have it here on our screen, we turn to one of the most remarkable visual meditations on law and virtue in the entire Western tradition. In fact, I've been falling more and more in love with this artwork since we chose it for our advertising. These are the allegorical frescoes of the seven virtues painted by Giotto in the Scrovegni Chapel in Padua, Italy, in the early 14th century. Now, according to some sources, the whole chapel was commissioned by Enrico Scrovegni as an act of penance and restitution, for his family's fortune had been built on usury. And his father, Reginaldo degli Scrovegni, is the usurer encountered by Dante in the seventh circle of hell. So Giotto painted the virtues, prudence, fortitude, temperance, justice, faith, hope, and charity, along one register of the chapel walls, and their paired opposing vices along the other. And they're rendered, as you can see, in a medium called grisaille, which is meant to give the appearance of stone carvings. So these somber virtues and vices sit at the base of an otherwise colorful chapel beneath narrative cycles of salvation history. So virtue and vice, we've not depicted the vicious ones, of course, but virtue and vice face one another across the nave. Now, I've never visited this chapel, but I wonder if the effect of standing between virtue and vice and the last judgment is on the far wall is sort of like standing in a courtroom, right? Where you know your character is to be sifted and weighed and judged and ultimately sentenced. But at the center of this space, you have virtue, right? Crowned and enthroned. And she is queen among the virtues. She is the hinge, ordering the soul outward to God and to neighbor, to the obligations of the common life, to what law is finally for. So it is these demands and these questions about how best to fulfill these demands that animate this symposium, now that we know the law is good on law and virtue. In addition to this evening's keynote lecture, I want to just share with you that our symposium this year, for the first time, also includes several private sessions with scholars from several disciplines presenting their ideas and research on this theme. So we issued a call for papers last year and received dozens of very fine submissions from all over the United States and abroad. And it was a challenge, but also a great honor, to narrow it down to our 13 participants. And in addition, we invited 4 distinguished scholars who will provide comments on those papers and guide our discussions in these private sessions. So I just want to recognize those 4 scholars. We have Stephanie Barclay from Georgetown, David Crawford from the John Paul II Institute, Rick Garnett from Notre Dame, and I don't see Michael Moreland is here in the back, right, from Villanova. So thank you. Our center's aim is to cultivate a community of scholars, and we are so grateful to each of you for being part of it. So now it is my very great honor to introduce our keynote speaker. Mary Ann Glendon is the Learned Hand Professor of Law Emerita at Harvard University. In addition to serving as a former U.S. ambassador to the Holy See, she has served in a number of distinguished capacities for our nation, including chair of the U.S. State Department Commission on Unalienable Rights, service as a member of the Commission on International Religious Freedom, and a member of the U.S. President's Council on Bioethics. She has also served the Church in many important ways. Professor Glendon was president of the Pontifical Academy of Social Sciences. She was a member of the Board of Supervisors of the Institute of Religious Works, also known as the Vatican Bank, and represented the Holy See at various conferences, including the 95 UN Women's Conference in Beijing, where she headed the Vatican delegation. She has received many honors, including the National Humanities Medal and election to the American Academy of Arts and Sciences. She has contributed to legal and social thought in several widely translated works. Her books have shaped generation of readers. I know I count myself among those. Many of you probably do as well, across many disciplines, law, history, and political philosophy. To name only a few, In the Courts of Three Popes, an American lawyer and diplomat, In the Last Absolute Monarchy of the West, I love that title, A World Made New, Eleanor Roosevelt and the Universal Declaration of Human Rights, which I will incidentally note, I learned so much about the UN Declaration, Eleanor Roosevelt, and also about Charles Malik, who I had not been introduced to before your book, and it's so, so important. Rights Talk, The Transformation of Family Law, and the New Family and the New Property. In sum, Professor Glendon has spent a distinguished career addressing precisely the questions that this center exists to ask. She is in the fullest sense a scholar of law and the human person. Her lecture this evening is entitled The Rule of Law and Legal Excellence, How Much Should We Worry? Please join me in welcoming Professor Mary Ann Glendon.
Well, thank you, Elizabeth, for that very kind introduction. And thank you, Mark and Elizabeth, for inviting me to participate in this symposium. I always love to come to Catholic University, as many of you know. It goes way back to the presidency of David O'Connell, when I came here almost every 2 months. And my papers, such as they are now reposing in the Catholic University archives, where I was amused to find myself, I was telling Mark, between old friends who both took me to the woodshed on various occasions, Richard Newhouse and Monsignor George Higgins. So Well, anyway, I love being here, and where else but here at Catholic University would anybody think to organize a conference, a symposium on two words that at least in most law schools we do not hear in the same sentence, law and virtue. I think maybe if some of you told your friends you were coming to a conference on law and virtue, they might have kind of raised eyebrow. They might have had a reaction like Mark Twain, who once was out walking with a friend and they passed through a cemetery and they saw a tombstone that was inscribed, "Here lies a good man and a lawyer." And Twain turned to his friend and he said, "You think there's room for both of them?" There's a long tradition, as we all know, of humor at the expense of lawyers, and it doesn't usually associate us with virtue. But the way I like to think about those jokes at our expense is that really, in their way, they are a recognition of how much our democratic experiment depends on the observance by lawyers, judges of all sorts, the observance of certain virtues, some of them in the form of legal ideals like the rule of law and judicial impartiality. And the invitation that Mark and Elizabeth sent out to us in the announcement of this conference was a kind of sober reminder that those legal ideals are not something that we can take for granted. And in fact, the invitation says, it refers to the disintegration of law, politics, and morality, and it asks us to share thoughts about rebuilding the legal and political institutions necessary to cultivating classical virtues in lawyers and citizens. Well, those references to disintegration of culture and rebuilding of institutions made me think of the situation in the book of Ezekiel, where the Lord went looking around in the city of Jerusalem and found that things were disintegrating. In fact, the Lord likened the cultural disintegration to a crumbling wall, and he went looking for somebody to stand in the gap and rebuild the wall of righteousness that guards the city. And that made me think of our moral culture and its current state, and it made me think of legal ideals like the rule of law, like judicial impartiality, that have stood as a wall guarding our democratic experiment. So when I go to a lecture, I kind of like it if the speaker gives me an idea, a little roadmap of where he or she is going, so you can kind of follow my argument, but also if you're wondering what time, when I'm getting close to the end. So I'm going to begin by recalling what the American founders had to say about civic virtue. And then I'm going to turn to what Tocqueville observed about civic culture when he visited here 50 years later. And then I'm going to mention some more recent ways of thinking about the rule of law and judicial impartiality. And I will end up venturing some thoughts, which maybe we can discuss in the Q&A, about the implications of those changes, recent changes, for American politics. So looking back at the founding, we all know the founders had a lot to say about law in connection with the new form of government they were bringing into the world. But what we don't remember so often is that they also had quite a lot to say about civic virtue. They had to think about civic virtue because what they were doing, what they were embarking on, was an experiment that made unusual requirements on both citizens and leaders. You could say it was a daring experiment, in fact, because it flew in the face of an axiom of classical political theory. The axiom was, You cannot have a republic, you cannot have a democratic republic in an extended territory with a large and diverse population. And many Americans, not just the anti-federalists, many Americans believed that. Many Americans thought we can't have a democratic republic because the population is already 3 million. The territory is immense, 3 million slave and free. But the framers of the Constitution, as you all know, they thought they could solve the problem with their ingenious design for a federal republic. But even so, that's going to depend. The ingenious design isn't going to work. The great laws aren't going to work unless you have a certain amount of character and competence in the citizenry. That's why John Adams famously said, "This Constitution was made for a moral and religious people." And even the deists, there's a new book by James Rosen on the effect of classical philosophy on the founders. Even the deists counted on classical virtues. So they know all that. But when you read the Federalist Papers, if you haven't done that recently, go back. It is full of brutal statements about human nature. They certainly had no illusions about human nature. I'll just give you a sample. Men are ambitious, vindictive, and rapacious. And how about this one? If impulse and opportunity coincide, we well know that neither moral nor religious motives can be relied on as an adequate control. Hence checks and balances. But there was no getting around the fact that the system ultimately depended on those same flawed human beings that they had been ranting on about. Finally, in Federalist 55, James Madison sounds a kind of grudgingly positive note. He says, there is a degree of depravity in mankind which requires a certain degree of suspicion and mistrust. But there are other qualities which justify a certain portion of esteem and confidence. And Republican government presupposes the existence of these other qualities in a higher degree than any other form. Not exactly a rave review. He then expresses his confidence in what he calls the present genius of the American people. But he left open a question that haunts us, I think, today. And the way he put it was this. He declined to speculate on what change of circumstance, passage of time, and a fuller population of our country may produce. That would require a prophetic spirit to declare, which makes no part of my pretensions. So it was encouraging when 50 years later, the population had quadrupled, but a French visitor comes, Alexis de Tocqueville, and what impresses him most is the vitality of our civic culture. Though he did predict that the legacy of slavery would cast a shadow over the country's future. As a lawyer himself, he was impressed by our Constitution and our laws, but what struck him most forcefully was what he called les mœurs, which gets translated as the mores, but I think today we would just say culture. He said what he meant by les mœurs was the whole social and intellectual state of a people, their customs, habits, and attitudes, and the institutions, families, schools, and so on, mediating structures of civil society, where habits and attitudes are formed, the seedbeds of the civic virtues. And the mores, he said, are regarded as the guarantee of the laws and the pledge for freedom itself. And he said, the guardian of the mores was religion. Now, he observed the relationship between law and culture as reciprocal. The mores undergirded the laws, but the laws had a certain effect on the mores. Some of the papers tomorrow are talking about the pedagogical effect of law. And law in the United States, which Tocqueville understood even then and even more so now, law is probably a more important part of the social glue that holds a diverse population together than a country where the population has more in common in the way of shared history, songs, and stories, and or where the law is viewed as a foreign imposition. So Tocqueville was very interested in the role of lawyers. They seemed to be everywhere, then as now. They were prominent in every part of social and economic and political life. And he was fascinated and somewhat amused to see that ordinary citizens, as he put it, were imitating the speech and manners of lawyers. No one, he told his readers, will understand American democracy without understanding the legal profession. Interestingly, he regarded that as entirely beneficial. I'm not sure that, well, never mind. He thought we were blessed to have such a large lawyer class. He thought they were a kind of social check and balances against the rowdiness and the impulses and excesses of Jacksonian America's population. So what was he seeing, we wonder? Well, maybe planners and problem solvers, people who checked for contingencies, people who thought ahead for the future. But that was 1830 and 31. Now, what if Tocqueville could have seen the legal landscape at the end of the 19th century? He would have noted many changes. The legal profession was still everywhere. It was becoming more diverse. And according to a Notre Dame Law School study, Thomas and Mary Schaefer, a long time ago, they wrote a wonderful book about the influence of the large influx of immigrant lawyers or immigrant communities from which emerged lawyers that, as the Schaefers put it, had a slightly different ethic from the small town lawyers and established lawyers that preceded them. And so around 1908, the American Bar Association decided it would be wise to introduce its first code of ethics. It was called the Canons of Ethics. And they held up a model of the lawyer as a special kind of public citizen who has a duty both to faithfully represent the client, but also to protect the integrity of the legal system. And I want to quote just one key provision from the 1908 code. A lawyer advances the honor of his profession and the best interests of his client when he renders service or gives advice tending to impress upon the client and his undertaking exact compliance with the strictest principles of moral law. Those canons remained in place until 1969, when the ABA decided to revise them. I don't know, not many people here remember the 1960s, but so those who remember it will know what I mean when I say that probably wasn't the best time to be revising a code of ethics. As Peggy Noonan memorably put it, the whole country went on a toot. So perhaps it's not surprising that the 1969 Model Code eliminated that duty to impress high moral and legal standards upon the client. It merely advised that it is desirable to call the client's attention to ethical aspects of a proposed course of action. Then, in 1983, that mild suggestion was eliminated. And the 1983 rules also omitted words like right, wrong, good, bad, conscience, character, but they added concepts of professional responsibility do not exhaust the moral and ethical considerations that lawyers ought to pay attention to. So that's where the rules stand, except There's one thing they never changed since 1908, and that was the strong and unambiguous emphasis on the lawyer's duty to protect and respect the rule of law. And they did so, they used words to explain why that was important that could have been written by the authors of The Federalist, by Alexander Hamilton in 78. They said, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. So the title of this talk, I think, said, Elizabeth came up with this good title. How worried should we be? I would say about the Code of Professional Responsibility, I really think that affirmation of the rule of law is very important, and I'm not terribly worried about the other changes. At least I don't find them as worrisome as certain other recent changes that I now want to discuss. Changes in the concepts of the rule of law and changes in the concept of what constitutes excellence in a judge. So I'll begin with the judiciary, and I'll venture the thought that for most of this country's history, the prevailing model of judicial excellence has emphasized impartiality, integrity, independence from outside influences, and self-restraint in the sense of being able to subordinate one's own personal views. Even a rambunctious judge like Oliver Wendell Holmes was famous for subordinating his personal views with a few notable exceptions. Other qualities traditionally praised in eulogies, encomiums, and legal literature: the elusive quality of wisdom, including a sense of where legitimate discretion ends and arbitrariness begins, maintaining principled continuity in the legal system, and the ability to rule in such a way that even the losing party can feel that he or she has been fairly treated. In the late 20th century, however, that ideal was rivaled by another model. I call the other model romantic, and I call the model that I just described classical. And when I use those terms classical and romantic, I'm deliberately avoiding the terms liberal and conservative because these two models appear across the judicial spectrum. But I would say the romantic model, the newer model, is characterized by boldness rather than self-restraint, compassion rather than impartiality, and the romantic judge is often praised for specific results. Now, obviously, no judge fits into those categories. They aren't hard and fast categories, but when I refer to the romantic model, I'm referring to a model of judging that regularly and habitually de-emphasizes impartiality, subordination of one's own views, and respect for precedent. And that's a mode of judicial behavior which, if it were to spread throughout the system, I think would have serious consequences for the rule of law. Which brings me to the question of what's been happening to the rule of law as a professed ideal. And that question brings us close to home, to the legal academy. I think it's safe to say that the rule of law is a system of established, publicly promulgated rules that are equally applied and impartially adjudicated, that ideal is valued highly by most Americans, with full knowledge that it's often violated. I think it's valued highly along with its corollaries that no one is above the law, that like cases should be decided alike, and that legal rules should not be applied retroactively. Everybody knows we don't have a perfect rule of law, but I think most people view it as an indispensable precondition to the achievement of almost all other political goods. So you might think it would have been a shock when, in the 1970s, the prestigious Storrs lectures at Yale Law School were delivered by what was then considered a grand old man of the law, Grant Gilmore, and he said in the course of that lecture, I've got to get the quotation here, "The rule of law is just an empty slogan. We are a nation under a government of men, not laws, and the only people who still believe in the rule of law are unreconstructed cold warriors." So what was the main criticism of Grant Gilmore's lecture in the Legal Academy? It was that he had said nothing new. And that was right, because by the 1970s, there was a whole school of thought in law schools that taught exactly that dismissed the rule of law as a mere cover story to disguise the exercise of power, and that scoffed at judicial impartiality. I remember well the Clarence Thomas hearings where Clarence Thomas had quoted Cardozo talking about how you put on that black robe and that's a reminder to you that you are stripping yourself like a runner for the race. There was such scoffing and laughing about that, because how could anybody be free of bias or unconscious bias? Again, I don't think most Americans are that cynical about the rule of law. It's not that they are unaware and concerned about problems, but when practical people see that something isn't working well, their thoughts generally move to, well, how can we fix that? I think Catholics get that point really easily. Thanks to the doctrine of original sin, we know that frequent violations with a spiritual principle doesn't mean that there's something wrong with the principle. It might be something wrong with us, right? And as for debunking the idea of judicial impartiality on the ground that no one can be perfectly free of bias, conscious or unconscious, the best response I have ever heard to that particular idea is what the anthropologist Clifford Geertz said. Someone said to him, you know, social scientists can never be completely objective. And Geertz said, a surgeon can never have a completely sterile operating field, but it doesn't mean he has to operate in a sewer. That seems to me to be the last word on that. So I have to say, how worried should we be about dismissing the rule of law in the academy? I'm not especially worried that some academics disparage the relatively small core of ideals that Americans hope they can count on lawyers to uphold. I do think a serious threat to the rule of law comes when officials of all sorts, judges and otherwise, fail to act in accordance with it to the point where it is so flagrant and pervasive as to undermine confidence in the whole system. But that goes right back to what is in the Federalist. Now, I'd like to turn briefly to just one more development in the academic world that would be worrisome if it were to have political traction. Now, if I'm not stating this school of thought correctly, I'm sure some of you will help me out on this, but there's currently a school of thought whose members have come to believe, at least as I understand it, that the more individualistic of our American ideals are so flawed that they carry within themselves the seeds of their own destruction, that they foster political divisiveness, and that they are corrosive of social cohesion. They're corrosive of the social and political structures that are the seedbeds of the virtues upon which our system depends. I think it's important to take those criticisms seriously. It seems to me that each one of those criticisms, loss of social cohesion, political divisiveness, there's something that is right about them, but there's something that's being missed. So here's the way I look at it. I think that what people who say that our ideals are flawed, that what they've noticed is something that was well understood by the founders. Most of the founders were attentive students of Montesquieu's Spirit of the Laws. And Montesquieu taught that every political regime has strengths and weaknesses, and that it's just a fact that the weaknesses are often closely attached to the strengths. And that sounds like an obvious point, but when you think about it, it has great implications. I was thinking about Nathaniel Hawthorne's story, The Birthmark, about the surgeon who marries this beautiful woman, and she's only got one flaw. She has a birthmark. And the surgeon says, if I only could take that birthmark out, then she would be perfect. And it doesn't end well because the birthmark was so attached to vital organs that his beautiful wife died. So, that Montesquieu point is not one to gloss over. And the founders knew that. And so the founders knew that if ideals like freedom or equality are taken to extremes, they can threaten the very habits and attitudes and structures upon which liberal democracy depends. But they didn't think that meant the ideas were flawed. They thought that what they had were powerful forces for political goods that had to be cabined and kept in balance with each other. And then Tocqueville added to that understanding a tragic insight. Again, it's a serious thing. Liberal democracy not only depends on certain cultural and social conditions, but it helps to shape those conditions, and sometimes in ways that threaten the survival of liberal democracy. And Tocqueville himself was particularly uneasy about the potential effects of degraded forms of equality and individualism combined with a growing love of material comforts, and he said certain habits that form in freedom could one day become fatal to that freedom. So I would say what contemporary critics of ideals like individual liberty or individual rights get right is that certain American ideals, if taken to extremes, can undermine democracy itself. What they neglect is the other half of Tocqueville's insight, that a deteriorating civic culture can undermine a regime based on those ideals. Each influences the other. They are reciprocal. I know a lot of you have written about that in the papers for tomorrow. And as for the claim that those ideals are divisive, I believe, again, the critics have noticed something important, namely that many of our ideals are in tension with each other. Freedom and equality, for example. Tensions among individual rights. They result from the fact that our founders drew their ideals from many different sources: Roman law, Greek philosophy, classical biblical religion, English common law. One could go on, and it was only natural that all those ideas from all different sources, as they were incorporated into our political traditions, sometimes they reinforced each other, sometimes they pulled against each other. It was thus inevitable that there would be differences and debates about their interpretation and emphasis. Ideally, those differences and debates are the sign of a vigorous and healthy democracy, a part of who we are, a part of what has enabled Americans of diverse beliefs to preserve a republic for over 2 centuries. But it's also true that those tensions are putting a considerable strain on that tradition. Should we blame the ideals, or are there other factors affecting our supply of citizens and statespersons with the requisite amount of competence in the civic arts of deliberation, compromise, consensus building, civility, and reason giving? And as for the claim that our individualistic ideals are eroding social cohesion, I don't think how you can explain the strength of that factor in view of the fact that European constitutions, many of them, elevate solidarity. Used to be called fraternity and liberty and equality and fraternity. Solidarity. The French and German constitutions both say this is a social state. They've got social responsibility right up there as an ideal. But they're suffering very similar symptoms of disarray in civil society, which makes it likely that some other factors are affecting social cohesion besides individualistic ideals. Urbanization, changes in world of work, technological developments, and not least what Fulton Sheen called in the 1970s the end of Christendom, by which he said, not the end of Christianity, not the end of the church, but the end of societies where social, political, and cultural institutions are permeated with Christian values. So it will not surprise you, now that I'm coming to the end of these remarks, it will not surprise you if I express the hope that our discussions tomorrow will include not only ideas about how to rebuild social, political, and legal institutions, but how to revitalize our civic culture. And I realize that's easy to say and practically impossible to think about it, but transformation of culture, isn't that what Christians are supposed to be doing all the time, 24/7, all the time? At least what I recall from the Baltimore Catechism is that that's what we're supposed to do, that that's our baptismal mission. And that was the Great Commission that Jesus gave his disciples at his last meeting on earth with them. And then the Fathers of Vatican II came along to remind us not only of that mission, but to tell the laity among us that the temporal sphere is our primary. We are primarily responsible for the renewal of the social and political and cultural sphere. So yes, it's a tall order, but for what it's worth, it's my sense, I hope you younger folks here will confirm this, it's my sense that something is stirring all across this country, stirring especially among young people, and that it is in that transformational mode. Now, finally, as to what we academics might contribute from our quarter, I'm going to leave you with a little saying that I have in a card that I keep in my desk drawer, and it is from a Jesuit theologian named Bernard Lonergan, and he says, "There's bound to be a solid right that's determined to live in a world that no longer exists. There's bound to be a scattered left, captivated by now this, now that new development, exploring now this, now that new possibility. But what will count is a perhaps not numerous center, big enough to be at home in both the old and the new, and painstaking enough to work out one by one the transitions to be made." Thank you.